Welcome to the channel. If you're first time joining, if you're returning, thank you for coming back. Things are ramping up and doing a lot of research into civil procedures and discovered a lot of things, and these folks are not playing fair at all. I think it's best to just jump off into it, and yeah, let's just go ahead and proceed. All right, thank you. So if you want to keep up with the status of these cases, you have to go to Peach Court, create an account, and go ahead and sign in. The case numbers will be in the description box below, and you can just copy and paste them in there. You can also search cases by name, but this is a lot easier doing it this way. So this is just one of the pending cases, just showing you how to actually get in there and to be able to view the docket sheet. And then the docket sheet has all case information, the case number, what court it's in, what type of tort claim it is, which is general tort claim, the defendants, the plaintiff, and all the plaintiffs. If you have people that aren't identified as of yet, you make them John Does. Right here is the date that the complaint was initiated, and it'll show everything that happens, every motion that's filed within that case, so you can go through and see everything. And at this point, all the summons have been issued to the defendants in the case, and then it'll show when it gets returned. Now, for the city of Lovejoy, for those of you who've been keeping up, so with that whole situation, the case did get remanded back to state court. Now we're at the point where in order for the case to get transferred, the defendants have to properly get served. So you can actually have a private server do it, but or you could do a waiver of summons, which is pretty much free to just waive that right, and that way it won't cost anybody anything. And there goes a motion to transfer. The amended complaint right after that, and then the summons that are issued, and the sheriff's office, which is crazy because Henry County Sheriff's Office is going to be the ones that have to deliver the summons, and they're being sued as well. So I wonder how that's going to go. I know there's a lot of naysayers out there, and a lot of people that would definitely discourage all this, right? But here's the thing: when you're fighting for justice, you gotta keep going no matter what. So with all these cases, then doing some research, and you can't actually have multiple cases in the same court venue and try to do them all at one time. It doesn't work like that. So what you can do is actually, it's called a joiner of cases or defendants into a single case, or a consolidation of cases, right? As long as it's happening within the same occurrence or same transaction. And with doing so, it makes it cost effective and easy on the court, because if you have multiple cases going on at the same time, it's just too much hassle, too much paperwork to keep up with. It's just too much going on. So there's different sets of rules that can go by. You know, I'm not an attorney, so let's run this, and this will probably explain it a whole lot better than I can.
The next question is, can defendants be joined? Let's say that Brianna wants to join with Sanitary Ninjas and the concert goers to sue Super Concerts and stages. That's where Federal Civil Procedure 20A2 comes in, and it allows the plaintiffs to sue multiple defendants in a single action if the same criteria are met. Let's look at it. Permissive joinder of defendants. Federal Rules of Procedure 28.2. Parties may be joined as defendants if each plaintiff asserts claims against each defendant arising out of the same transaction or occurrence, or same transactions or occurrences, and each claim against the defendants will involve a question of law or fact common to all parties. Same as 20A1, except we're dealing with defendants. So back to the question of how can this play out in court? Well, we can have a single plaintiff sue a single defendant. We can have multiple plaintiffs join together to sue a single defendant under Rule 20A1. We can also have a single plaintiff join several defendants under Rule 20A2. And we can also mix them together. We can have several plaintiffs join together as plaintiffs and sue multiple defendants, join multiple defendants under Rule 20A1 mixed together with Rule 20A2.
So if you've taken a time out to actually go into Peach Court and review these cases and kind of just go through the docket, hopefully you grasp the concept of actually what's going on. So we have a city, actually two cities, but in one particular case, we have a city, the county, and the state that's being sued for damages, right? Now, it would be, I'm going to say, impossible to do. Actually, kind of is by law. What would happen is the courts would actually make you decide which one you're going to pursue. You can't pursue all of them. It's like you got to pick one in a sense. But if they all happen in the same occurrence, in the same transaction, you can combine them into one, right? Now, which is in the plaintiff's favor, is that it was a clear civil rights violation, and not only that, the plaintiff went to trial and beat it. So regardless, at the end of the day, as a matter of fact of law, after the defendants are properly served and the case is actually brought before the judge and he gets to read over the complaint and stuff like that, it's pretty much summary judgment. There's no defense that the defendants could come up with. I don't care if they have the best lawyers. It's the law. They broke the law. They didn't follow the procedures, so they're kind of hit. Also, when it comes down to the city of Lovejoy, that's another reason why they ran to the federal government. If you, a matter of fact, with that, give me a second. With that, in the federal courts, if you try to sue I think it's city, municipal, county, and state entities, can't be sued in the United States courts because they have sovereign immunity. The state waives sovereign immunity only to the extent where the matter provided in this article only with respect to actions brought in the courts of the state of Georgia, the state courts. This does not waive any immunity with respect to actions brought in the courts of the United States. So always keep it in the state court. It's impossible. So don't ever try to do it there. It's always in the state. Always do that in the state. This is the thing. These attorneys don't want you to know a lot of this. You'll spend buku money and a whole lot of time, and they'll drag it out like crazy. And the thing is, like, any in this particular situation, any attorney that would end up taking this case would botch it. They would do it intentionally to try to just destroy any chance of the plaintiff actually winning the case, which is already won. It's just take the time doing the paperwork, getting all the plaintiffs and getting all the defendants served, which is crazy because the county, Henry County, is being sued, but yet the sheriff's officer is the one that's delivering the summons to these individuals and to themselves. So I want to see how that works out. Like, with the summons that's going to Henry County, right? They don't even have to go nowhere. It's right there. The sheriff's office is getting sued, so they're like actually just giving the plaintiff, giving the summons to themselves. Let's see if they actually do that, because there's no excuse for, oh, we couldn't find them. It's right there in the same office, right? So let's look at this next clip, and this attorney explains a little bit more about consolidating cases.
Business litigation attorney, which means that my business is to protect your business. Today I want to talk about what a motion to consolidate is. Now, the reason I'm thinking about what a motion to consolidate is, I was in court today, and I had a case where there's three parties. There's my client, who's a consultant, who hired a contractor to work on a homeowner's property. Now, my client is suing the contractor, and that case is here in Richmond County. And the homeowner, after I filed the case in Richmond County, is suing the consultant, my client, in Kings County. Now, what I did is I sued also in Kings County then. Once that action started, I sued the contractor in Kings County on a different cause of action, not the same one. I sued him, and then I wanted to bring all the cases together because they should all be heard because they're all in similar circumstances. And the reason is, you don't want to have related cases, a case in one county doing one thing, and then something happening completely opposite in another county, or even in another court, because you can get conflicting rulings. You can get conflicting things that are going on. And let's say the reason that the homeowner is suing my client is really the fault of the contractor, and that all the causes of action are related. Okay, you don't want differing rulings. You don't want this, they're all need to be put together in one set of circumstances because they're all related. And the way you do that is with a motion consolidate. Now, so what I did, I was the first one to file, so I made a motion consolidate in Richmond County. And as long as there's no real good cause to not consolidate it, it will be consolidated. And that's the whole point. When there's two actions arising out of the same set of circumstances, you want to put them together. Now, you can't always put them exactly together because there could be prejudice, there could be bias, or something along those lines. So sometimes they're just joined for trial. Now, what does that mean? When something's joined for trial, there's still two separate cases, but they're going to be heard at the same time. And sometimes that's the best you can get out of a judge or a court. But the goal is always when there's similar circumstances, so you're not getting conflicting rulings, you're not getting conflicting pieces of information, that you consolidate it under one court, one judge, so that everything can be together.
So pretty much with the city, the state, and the county, those cases are going to get consolidated. Now the other one with Lovejoy, that's a completely separate incident. It's two separate transactions or occurrences, so it has nothing to do with that. That doesn't, it's two separate things. That whole thing was just getting the plaintiff served, which is going to hopefully be, I don't know, because these are, all right, let me explain something. There's a thing, you probably never heard this term right here, called parallel construction, right? Even people listening to crime don't even know this. They haven't found out about it until they get arrested and get 20,000 years in prison, right? The thing called parallel construction. They use this technique. It's when multiple agencies pretty much band together for one common cause to try to catch a suspect or something like that, but they can't go over into another county. So they ask a certain next county over to help them to keep track of this individual or group of individuals that they're trying to build a case on. So they're like surveillance, they'll run surveillance and all type of stuff. A lot of it would be illegal as hell, but who's gonna know? And then the thing is, once they catch them or wherever the case may be, they might have gotten all this evidence illegally, which is fruit of a poisonous tree. You can look that up too. That's a whole nother, it's a lot when it goes to that, but you got to think of it. You got multiple entities that you're suing, and you're completely right. The case is already beat. All it is just going through the motions. Even if it goes to trial, like there's no defense to this stuff. It's too much evidence, and then the just let me stop right there. All right, so let's hit this law library and let me point out a couple things to you guys. Validated. So this is where that comes in. So we got trials and stuff like that. All right, this is under this code right here. So the consolidation. So this is very important. When actions involving a common question of law and the fact pending before the court, if the parties consent, the court may order the joint hearing or a trial of any of all matters, issues, in action. It may order all actions to be consolidated, right? And may make such orders concerning to proceedings therein as it may tend to avoid necessary cost delay. So that makes sense. So if you got three, four, or multiple cases going on at the same time, it'll just be more cost effective, more convenient for the taxpayers to just have one single trial. Right along. And then there's another thing called joiner. So if you got multiple defendants, you could join them in the case. Any person who is subject to service of process shall be joined in a party if, in its absence, the relief cannot be afforded among those already in the parties, or he claims the interest of relating to the subject of the action situated in disposition of action may be absent. So pretty much what this is saying is like, okay, if you got multiple cases going on, and if some of the defendants are not there, but it would impair the final outcome of the case. Is like, okay, let's say you're driving, you get into a wreck, and then there's 2 or 3 cars that were hit, and they all hit you, right? and like 2 of the defendants aren't there. Now they all have to be present in order to pursue. So this is where this comes in, and it gets a little bit more technical where depending upon where they're located and venue and but pretty much that's the foundation for that right there. There is so much more that I want to go into detail about, but I can't because this is the internet, and I definitely have my opinions and I have some things to say, but I have to use what's the word I'm looking for? Not resilience. To be humble. To humble myself and curb my enthusiasm for getting ghetto and letting the convict come out, right? This is the thing, because these individuals, let me tell you something about the system, and this is what I don't like about the system, right? Somebody commits a crime, they go to jail, they do their time, they serve their debt to society, they get out and try to lead a productive life, right? Then you got other people that you might let into your life who may know of your past, and use that and exploit it, and if you don't dance to their fucking tune, then they'll go and take this information and use it against you, and then then you got all these authorities sniffing up your butt crack, you know what I'm saying, like literally, man. It's when you read paper, if you read somebody that you never met, right, you read into their past and stuff like that, you never met them personally, and then you get automatic, because I read some cases, I'm like, damn, the person's messed up, whatever, blah blah blah, but then I've read cases where I actually know the person and met the person like firsthand. I'm like, damn, what they putting on paper, this is not what, you know what I'm saying, reading these transcripts, I'm like, damn, the prosecutor was going in, I'm like, bro, you like the coolest dude I know, I'm saying, like, you laid back as hell, you were not this what they're trying to make you out to be, and it's messed up. It's messed up. It's like it how can I put it? I'm trying to I'm thinking of to be politically correct and trying not to curse and get ghetto, right? It's like they want you to be what they portray you to be on paper, if that makes sense. And people automatically assume that if you ever been incarcerated, you've been in jail, that you're automatically ignorant. Now, a lot of people, if you never came in contact with certain individuals, or you never knew their past unless they told you, you'd be like, dang, I didn't know that you was incarcerated, second, third, and like can't get out, right? Kind of getting upset. And in situations like this, where actually individuals' past has actually benefited them, because when you've been done wrong so many times by the system, you get tired of that shit. You know what I'm saying? And what I've learned is to read and study and learn. That's it. You know what I'm saying? All of this is reading and doing paperwork. I mean, it could get complicated, it's frustrated, but when your life is on the line, that's a fucking motivation right there, buddy. You know what I'm saying? And like, yeah. And with that said, man, thank you for watching. Hopefully I catch you on the next one. I'm gonna jump off into some other things, but I encourage you to go on the Peach Court and keep up with the cases. The cases will be in the description box below. And let's see where this goes. These summons then got sent out to all these government entities, and it's crazy because the same Henry County Sheriff's Office is being sued, and they're the ones that they're getting paid to do a job. There's a service. It's not them individually, but they gonna feel some type of way because it's their buddies. So let's see how that shit plays out. There's so much I want to tell y'all, bro. It's insane. It's insane, and like. I'm just gonna, y'all, boy. Hope I'm here for the next one. That's all I'm gonna say. Peace.